his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above.
There are quite a bit of expectancy around you.
Sorry?
Maybe there are many expectations.
Yes, they are working.
Oh, thank you. Thank you. I hope you know the origin of the word. I don't know.
Pepsodent is aware that globally 1 in 2 children suffer from cavities. Give her Pepsodent. It repairs tiny holes and forms a protective layer for maximum cavity protection, so she can grow up with a confident smile. Every smile matters.
Yeah, they're sitting on the other side. You know what he's telling me? He's telling me your mother will name you depending on how you see the potential.
You came from Sega all the way. I don't know. From Sega. It's not necessary.
Ceremony work would have been better than here.
Yes, it's bigger.
Ceremony work.
But lakini haipangikangi vizuri. Unajua haina bench kama hizi.
Supreme Court na nini president petition ilikuwa inapangika.
So every lawyer have
You get a desk.
Get a desk.
Because
Do you have the
obviously be congestion.
There's something on the check.
Si maiki ni haya. Icon pa. Ambao ni chini hapa.
Unaulizwa weka t-shirt down. Ceremonial.
Bigger court, yes.
Nani hapo? Anapanda.
How are you? Salama. Asante.
Ngoja nimuulize. Unapanda mjini?
Mkulima, je, siku zako huwa hivi? Kuvuta maji kwa mikono, kujaza mitungi ina
morning again. Justice Eric Ogwela, Justice Anthony Mrima, Justice Dr. Frida Kibiru, presiding over petition E565 of 2024, Rigathi Gachagua versus state law and others.
My lords, your ladyship, for recording purposes, For recording purposes, my name is Paul Moite, appearing for the petition. His Excellency Rigathi Gachagua in petition E565 of 2024, in which he is the petitioner. And I do so, my lords, your leadership, with my learned friends, Senior Counsel Elisha Ongoya, Tom Macharia, Sonia Victor Ogeto, Faith Waigwa, John Jomo,
Present.
Ochi Dudley, you want me to use this? Ochio Dudley, and finally Willis Echesa. My lords, your leadership, given the large number of parties and their respective counsel, with your concurrence, my suggestion is that counsel appearing for the different parties introduce themselves for the sake of arguments. I thank you.
My lords and my lady, I was waiting for the second petitioner, but in the matter for the third petitioner, my name is Muge, and I appear together with my colleague, Uncle Jen Jerry Minor.
Good morning, your lordships, your ladyship. For the 4th to the 8th petitioners, my name is Ogada. I appear with my brother Sakimpa. Thank you.
Good morning, my ladies, my lord. My name is Wanjiru. I hold brief for Mr. Kibe Mungai. We appear together with Kibe Mungai for the 10th to the 41 petitioner, together with Mr. Ole Kamwaro, Mr. Nyamu, and Mr. Simon Mboro. Equally well, my lady, my lord, for the 44th to 49th petitioners, the quorum remains as stated.
Your lordship, my lady, my name is Morala Omoke,
43rd petitioner and counsel, and petitioner in E027 of 2024. I'm not for which party. I appear personally. You are which petitioner? I am the 43rd petitioner, your lordship.
Once more, permit me to also place my senior Mr. Maanzo on the quorum for the 44th, 45th, 7th, 8th, 49th petitions.
That's my lord.
I'm instructed by the Honorable Attorney General to appear on her behalf and I am here with my learned junior, Mr. Christopher Marwa, present. With your permission, I have taken the liberty of introducing everybody here. I have my learned friend, Mr. Gumo, Mr. Yamodi, and Mr. Uma appearing for the National Assembly. I have my learned friends, Professor Thomas Jenda, Senior Counsel, and Mr. Mukele appearing for the Senate. I have my learned friend, Dr. Mukele Fiampolo, Senior Counsel, appearing alongside Moses Kipogei, Ken Melly, Kenson Natalia, Boniface Maura, and Steve Ogola for the Honorable Professor Kidiki, the second. Sorry, I am corrected there. The Honorable Professor Kidiki, the second interested party. And I am advised that there is Mr. Bore for the first and 8th respondents, and that should come out as well. And the interested party. Thank you. Appears for the Senate, and who is my apologies.
The present is Ms. Sancho.
My lords, my name is Michael Moshemi. I am here together with Paul Kubula for the 9th respondent. Present. Requested to introduce Mr. Hira, who holds brief for Dr. Kamoto for the 10th respondent.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things on track. I create custom statuses to organize my progress exactly how I want it. I like to add the action items field so AI can show me the next steps. I add my teammates as watchers so they're in the loop.
Thank you very much for attending the forum. There's some preliminary issues we want to address before we proceed. The first point is
we were not able to get the ceremonial hall to where we could have been much more relaxed than we are in this place, because the ceremonial hall is being used for other purposes. That was a promise that we made. We are not able to keep it. Therefore, we apologize for that. To ameliorate the issue, we have created an overflow courtroom, that is court number 325, where there's a screen and therefore you can inform others who may want to hear that there's an overflow courtroom number 325. The second direction we want to make is that we had selected 3 days for the hearing of this petition. That is today, tomorrow, and the day after tomorrow. But for reasons our ability, we are not able to proceed tomorrow or the day after tomorrow. This is so because one of us here, Justice Murima, is a member of the Judicial Service Commission, and they are carrying out interviews for the Supreme Court. That is an assignment which he cannot avoid. And therefore, we will adjourn after today. We wanted to let you have this information well in advance so that you are aware even as you argue the petition. For that reason, we have decided, and we hope that you will accept this decision because getting a date is very, very difficult, that the second hearing will take place on 7th of May, and the third hearing will take place on 8th of May, all starting at 10 a.m. The last direction concerns petition number 586 of 2024. Is Councillor Pinyanji in the house? Mr. Pinyanji?
Yes, my lord, I am online.
All right.
I was informed that it would be hybrid. I appear for the petitioner. I'm present.
Yes, we will mention your matter, this petition number 586 of 2024 at 4 p.m. today.
At 4 p.m. today?
Yes.
Thank you very much.
Thank you. I think we are now ready to go.
May I seek a small clarification in respect of today, up to what time in the morning section does the court intend to sit? In other words, when do we break for lunch? When do we come back? If we break for lunch at all, we are in your lordship's hands.
I think it would be prudent for us to break at 1 and come back at 2.
Thank you.
Yes. Senior Counsel Paul Gote, we would like to know how many will be addressing us so that we allocate time.
For the 8 counsel appearing for the petitioner, the first petitioner, my lords, your ladyship, bearing in mind that the first petitioner is the subject of the impeachment, the main pleader in these proceedings, we have divided the highlighting of the submissions amongst the 8 of us. Perhaps my learned friend, Senior Counsel Elisha Ngoya and myself will take a little longer than the others.
People talk about the divorce glow up.
I started healing at the scene of the crime. Actually shaved off my hair. Like,
I was so done, Kechi, like I'm not even kidding. I was so done. But now when I started healing at the scene of the crime, I started glowing up inside the scene of the crime because, I mean,
Wow.
yeah.
There is that stigma where you just don't get people supporting you the way they supported you before. Will tell you immediately, I was not ready at all.
Oh, really?
Proposing. I am proposing, in other words, my lords, that you kindly allocate me 1 hour, give or take, and Elisha Ngoya 2 hours, give or take, and the others 30 minutes, give or take. That will be adequate for us. In fact, this Honorable Court had indicated when we last appeared before the court that we would have to date for the petitioner's case. And because there are many petitioners, I was just saying the person most affected is the first.
My lord and my lady, on our part, the third petitioner would request to be given 1 hour.
If you may please the court, the money for the petitioner will just take 20 minutes to let us finish.
Lordships, between myself and my brother Sakimpa, will equally need 1 hour.
Even as we left those petitions, bear in mind that a day has its own
We endeavor to make it shorter.
All right. I think we will proceed on the basis that we'll give you as much time as humanly possible within a day.
We agree. Hello? May I start, Your Honor?
Yes.
My lords, your ladyship, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this noble court on record, on behalf of His Excellency Rigathi Gachagua, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency Rigathi Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish, again, my lords, your leadership, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the quashing, if this court agrees with our submissions, the quashing of the unconstitutional impeachment. Number two, payment of the remuneration with the court to bear he would have otherwise earned, this is the first plus
of course, all the benefits as per the law.
Is having for stating
Finally,
this case. I believe
for the period of 2.5 years,
Thank you.
that His Excellency.
So what are you proposing? I am proposing, in other words, my lords, that you kindly allocate me 1 hour give or take, and Elisha Ngoya 2 hours give or take, and the others 30 minutes give or take. That will be adequate for us. In fact, this Honorable Court had indicated when we last appeared before the court that we would have to dig for the petitioner's case. And because there are many petitioners, I was just saying the person most affected is the first.
My lord and my lady, on our part, the third petitioner would request to be given 1 hour.
If it may please the court, the money for the petitioner will just take 20 minutes to let us finish.
Lordships, between myself and my brother Sakimpa, we'll equally need 1 hour.
Even as we left this submission, bear in mind that a day has its own
We endeavor to make it shorter.
All right. I think we will proceed on the basis that we will give you as much time as humanly possible within a day.
We agree. Hello? May I start now?
Yes.
My lords, your ladyship, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this noble court on record, on behalf of His Excellency Rigathi Gachagua, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency Rigathi Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish, again, my lords, your leadership, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law. Finally,
for the period of 2.5 years that His Excellency Rigathi Gachagua served as the second Deputy President of the Republic of Kenya. It is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment cannot and could not have been retrospective. That is the submission. My Lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his father amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2024. Number 2, his bundle of authorities and case digest, dated 7th of October 2025. And number 3, the first petitioner's written submissions, dated 7th October 2025, which submissions are the ones we are highlighting today before this noble court. My Lords, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My Lords, your leadership, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this honorable court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go. That the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submissions, paragraph 8, the Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fairness, fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution, the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President the first petition the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced a schedule on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination. This Honorable Court will be taken through all that. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite, on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by Rigathi Gachagua. And also RG 12, volume 9, pages 1752 to 1758, communication from the chair. Now, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the Prime Minister. There are many examples of the parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that there are breaches of the Constitution, and you will be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the Deputy President being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is the last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kioko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the Deputy President. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the Deputy President meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I say, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the Deputy President to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different countries. My Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations was that, whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, Your Leadership, my learned friend Deputy President here, and myself had the privilege of arguing the Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other reason. No, they didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case, deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's a very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, Ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office by impeaching the Deputy President on the basis of a section that had been nullified by this court. What he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. My Lord, you find that authority, paragraph 62, allied case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in Ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. And you find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in Ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight of property. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is Cap 206 of the laws of Kenya. You will find in Part 3, Civilian Authorities, the heading, Effective Civilian Authority. They then say that the Cabinet Secretary will be the civilian authority oversight. The Cabinet Secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Leadership, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Rigathi Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Wengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present evidence that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito Gachagua. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queen's Gate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my lord, in RG2, volume 2, pages 211 to 214. Lords, although the mover of the motion listed 32 companies associating them with the petitioner, first petitioner, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you'll find that in RG2, volume 2, pages 214 to 218. The Speaker of the National Assembly, again, a good professional colleague who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence, rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you will find that as message of the Senate, number 025 of 2024, approval of special motion, RG3, volume 6, 745 to 745. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that, one, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)(a) of the Standing Orders of the National Assembly. 2,